All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. All persons having been before this court are admonished to draw an eye and give their attention to the court. Now sitting.
Thank you, and please be seated. Well, good morning, everyone, and welcome to the Kansas Supreme Court. I am Justice Eric Rosen, and obviously unique to this week's docket is that Chief Justice Marta Lukert will not be participating this week, and I will be filling in for her in her absence. And I want you to say, I want to say that she wants everyone to know she's doing well in her recuperation. Thanks everyone for her, for all the well wishes she's received. One more note I want to make is that today marks the first oral argument for our newest Justice, Larkin Walsh, who was sworn in earlier this fall. We all very much appreciate her contributions thus far and look forward to working with her on this docket and future dockets as we engage in our challenging work. And as I look out to the gallery here, I note that we have some guests present here today. And if you'd like to come forward and announce your presence and who we're fortunate enough to have in the gallery here today.
Justices, we have a wonderful group of students in the Bachelor's Studies program at Washburn University. And so we've got some up and coming legal professionals and they are very excited to be here. So thank you very much.
It's good to see you again.
Thank you.
Yeah. And welcome, students. It's always good to have fresh faces here. It gives us kind of a great hope for the future. Thank you for being here. One more thing, for those of you that are unfamiliar with the court processes, I would like to explain the justices, all of us here, are present and familiar with the facts of the case and the parties' arguments. We've read the briefs authorities relied on in those arguments, reviewed the district court record, and otherwise prepared for this morning's arguments and this week's arguments. And we look forward to the arguments in our exchange with the attorneys here this morning. And I will now ask Mr. Doug Shima to please call the docket.
Thank you, Your Honor. Next is the court. First case on the 9 a.m. docket for Monday, October 27th, 2025 is appeal number 127378, State of Kansas versus Daisha Butler, Shawnee County.
May it please the court, Peter Meharry for Daisha Butler, present and ready for argument.
Good morning. May it please the court, the state appears by Deputy District Attorney Jody Litfin, present and ready for argument.
Second case is appeal number 127008, State of Kansas versus Verlee McCullough III, Wyandotte County.
May it please the court, James Latta of the Appellate Defender's Office. I'm representing Verlee McCullough. I'm ready for argument, and may I please request 3 minutes for rebuttal?
That's noted. Thank you.
Thank you, Your Honor.
Good morning. May it please the court, the state of Kansas by Assistant District Attorney David Greenwald, present, ready for argument.
Thank you, Mr. Greenwald.
Your Honor, that concludes our 9 a.m. docket.
Thank you, Mr. Shima. I will now call the case of State of Kansas versus Daisha Butler. Case number 127378. Counsel, please come forward. Mr. Meharry, you may begin your argument.
May it please the court, Peter Meharry for Daisha Butler. If I could request 3 minutes of my time for rebuttal, Your Honor.
Thank you.
This case arose out of an altercation here in Topeka between two groups of individuals. Ultimately, one individual lost their life, and my client was later convicted of murder as a result. What I would like to do today is talk about the instructional issues, because I think when you look at the instructional issues in this case, what you find is that the jury, because of those instructional errors, simply did not have the framework they needed to properly evaluate this case. And I'll start with the instructions with regard to self-defense. That was a key defense in this case. And the district court over objection gave what we commonly call a mutual combat instruction. And it's our position that while the district court did take a lot of language from this court's opinion in McCullough, it was still an incomplete instruction and would have misled the jury into how it can apply and how self-defense would apply in this case. Specifically, the district court failed to contain language within the instruction that even if you are involved in mutual combat, self-defense is still available if it's used solely to protect your life and not solely to inflict harm. That was left off, and the resulting instruction would have led the jury to believe that self-defense was not available in this case because my client never withdrew. The language in the instruction specifically states that for it to apply, the defendant has to do everything in the defendant's power to avert the killing and has to withdraw. So that omission is problematic because it misstates the law and would mean for the jury, self-defense doesn't apply here. It takes off the table a defense that my client put forth when it should not have been taken off the table. The jury still should have been able to consider that defense as it was considering the facts of this case. As that was a key defense, we don't believe this court can find that omission harmless. As I said, it was central to the case. There was a lot of discussion about the altercation between these two groups of individuals, how it started as a physical altercation became a verbal altercation, but there was also continued talking, threats, etc. between the two groups. My client repeatedly stated that she felt threatened. She felt threatened for herself. She felt threatened for her child who was with her. That all should have allowed the jury to consider self-defense in this case.
Let me ask you a question that I wasn't sure. But was her child in the house or outside?
My understanding of the facts was her child was with her.
When she shot the gun,
Initially, she came with her child. I'm not sure exactly. I would argue that the facts aren't necessarily clear on that. But my understanding is she brought her child with her. At some point, I'm not sure, she was alleged to have fired the gun. I don't know exactly that the record is clear as to where the child was at that point. But she did clearly state that she felt threatened, and she felt threatened for her child as well when she was interviewed by the police. So whether or not the child was right at her side or somewhere else during this altercation, I think the evidence is clear that she felt her child was in danger just as much as she was. And that's why self-defense should have been an option for the jury to consider. But this instruction, because of the omission, again, takes it off the table and would not have been considered by the jury.
What evidence is there that, I mean, you've explained the subjective view of your client, but what evidence would you point to that belief was objectively reasonable?
I think you have an ongoing altercation between two groups of individuals. There was a physical confrontation between them. There was continued talking, trash talking essentially between them. So I think there is this ongoing altercation that would allow for the jury to at least consider it. And the problem isn't necessarily, okay, the jury considered it and rejected it because of that reason. The problem is the jury couldn't even consider it with the instruction. And we believe the district court properly found that self-defense, an instruction on self-defense was warranted given the evidence. But then when it gave the mutual combat instruction, it essentially took it away. So we believe it should have been properly considered by the jury, but because of this instruction was not.
but I don't think I understand. What is the bottom line answer to Justice Wall's question? What is the objective? I mean, because she was shot in the back of the head as they were retreating, right?
The evidence was that the individuals were still arguing amongst themselves. The evidence was that my client fired a warning shot. And one of the warning shots struck the individual who lost their life. But I think you have that ongoing altercation between these two groups of individuals that had been physical. And there's no reason to think that it's outside the realm of possibility that would not have become physical again because of their continued argument.
Well, Mayor,
Further,
but I still don't get that because, you know, I'm just wondering whether, you know, objectively, whether a self-defense instruction was even appropriate factually, because she said she feared for her life, but, and I've looked at the facts, you know, I mean, there's obviously different perspectives about what the facts were, but any way you look at it, she was shot in the back of the head. It was not at close range, right?
no, the evidence was it was not at close range.
Right. And so what, you know, how could she objectively had feared great bodily harm?
I think she could have objectively feared that because there was that ongoing altercation, as I said.
I did.
The other thing I would tell the court is that if you look at the evidence, the shot was to the back of the head. It was to the top of the skull with a downward trajectory, which is consistent with the testimony that she did not fire at, but she fired a warning shot. So the evidence as far as self-defense.
But how does that, if she fired a warning shot, how is that self-defense?
Because she felt threatened. And she had a right to use some level of force. And this bleeds a little bit into why involuntary manslaughter, imperfect self-defense should have been given. She has a right to use some level of force to defend herself, such as firing a warning shot. Now, certainly the jury could have found that excessive. They weren't given that opportunity to make that decision. But she had the right to defend herself in this ongoing argument between these two individuals, these two groups of individuals.
So there
And
would really be no difference between, you know, if there was, I mean, you're saying an ongoing altercation, but really the altercation kind of ended because you know, they were retreating.
I would argue it wasn't ended until the shots were fired, because there was an ongoing altercation up until the time she fired those warning shots. So when she fired those warning shots, they were arguing amongst themselves still.
What facts in the record are you relying on?
The testimony from multiple witnesses that said there was continued trash talking between the two groups of individuals. Ms. Brown testified that there was arguments between the two.
So trash talking, you can kill somebody if you feel in fear of trash talking.
If you feel your life is in danger,
How is that objectively fear? You know, what I don't get is, okay, even if they were you know, like my son does, as he's retreating, spouting off, you know, then you're saying that's objectively, that evidence is objectively justifies fear of great bodily harm?
it could, it depends on the circumstances. I think here she had that right to defend herself, given those circumstances. And at the end of the day, when you're looking at whether or not self-defense should be given, we're talking about some evidence, a very low standard, because this is a factual question and we want to put it in front of a jury. We want the jury to decide these facts because they're the one listening to the evidence, looking at the witnesses. So they should be deciding these facts. If there is anything that can support it, and we believe there is, and the district court did, and that's why he gave it.
Different. Now you're moving to something else, but I mean, this is, you know, this claim of error is, we're looking at whether, isn't that a matter of law, whether it's objectively reasonable?
I think if there's any evidence that could support that finding, that is sufficient. I don't think this court can say just point blank, we're deciding this issue.
No, I know, but is there evidence to support? Right. I mean, I guess that's what I'm saying too.
Maybe we're talking past each other. I don't
Okay.
know.
Go on with your argument.
Sure.
I'm sorry.
My point is simply that there was evidence for the self-defense. And that is a question then that should go to the jury. But with the mutual combat instruction, what the district court gave, it then took away because it misstated the law on mutual combat, such that self-defense would not have been considered by the jury when it should have been.
While you've got a couple minutes left, can I focus you on what's giving me some problems, which is the sufficiency argument? I understand there's no evidence that she knew the victim was under 18, right?
That's correct.
And so what's your argument on the sufficiency issue?
The argument is, number one, she didn't know. She had no knowledge. And she wouldn't have reason to know under those circumstances. This was a fight that occurred late at night. This was two groups of individuals that had been essentially texting back and forth throughout the day, trying to set up this fight. I think the logical conclusion is this isn't a child. This is an adult that's looking to get in a fight along with her friends, and we're going to set this up. And at, I don't know, it was like 11 o'clock at night. We're going to meet up and have this fight. So I think when you look at,
I mean, this isn't a strict liability crime, as I view this. So she's 17. I think somewhere in the record, we found that she was 17 and 3 months. So what's the evidence? I mean, I'm trying to make your argument, frankly, but I'm trying to say but I need you to confront what evidence there may be that's counter to your position, which is there any other evidence anywhere that closes the gap of that 9 months in terms of what would indicate to your client that this victim was under 18?
I don't think there is that evidence that would tell my client you're dealing with a minor. The evidence here, again, was that she was full participant in this with this other group of individuals. My client didn't know her personally in any regard. So I don't think there is that evidence that she would have a reason to know that she was a minor.
Is it reason to know? Or is it that a defendant acts recklessly when the defendant consciously disregards a substantial and unjustifiable risk that certain circumstances exist?
Well, I would think knowing, consciously disregarding an unsubstantial risk.
A risk that she was under the age of 18?
You would have to consciously disregard that. You would have to have some reason to know, hey, she looks, she's 5 years old. That, obviously clues. You have to have something that would tell you that she is a minor so that you can then consciously disregard that risk. Because the risk, child endangerment, what it focuses on is putting children at risk. And that's the risk you have to consciously disregard. That not just that you're creating a danger, but that you're putting a child at risk. So to consciously disregard that risk, you have to have something to tip you off that, hey, this is a minor, maybe I should back away, or whatever the case may be.
She had her 3-year-old with her. That's a minor.
That was never the state's theory, that she put her 3-year-old in danger. The theory always was, and the felony murder was based upon child endangerment of the individual who lost their life. Whether or not the state wanted to get creative in charging, they did not. But their charge in this case was based on putting the individual who lost her life in danger. And that requires something to tell my client, hey, she's a minor. Otherwise, you don't have sufficient evidence for that charge.
Can I ask a question? So this sufficiency of the evidence argument is based on an assumption that the statute itself requires that knowledge element, the intent element, here it's reckless, to apply to the child's age as well as the situation in which the defendant is putting her. Could you talk about why you think that applies to the child's age, particularly in light of the instruction that the jury received in this case? So I'm looking at instruction number 13. And it would not suggest that any reckless or any level of culpability applies to the age requirement.
I think it does, because the purpose of the statute, it's not just creating, as I said before, it's not just creating risk. It's creating risk for a minor. That's the purpose of the statute. So I think it does require some level of knowledge, some reason to think that you are dealing with a minor and you are putting that child in danger. It's not just about, okay, there's a minor and there's a danger. They're married by this statute, and you have to have both, I think.
And the authority you rely on for that, would you point us to a Kansas case? I think you have Herndon and.
Yeah, there was certainly the, I want to say it was the Herndon case. I think that was the Court of
Patillo?
Appeals case, and then there was a case, Patillo, I mean, I butchered the name, Patillo out of this court. Herndon kind of said, or it could have been read to require actual knowledge of the age of the minor. This court said, no, it's not actual knowledge that is necessary, but some reason to think, reason to believe that you are dealing with a minor. So again, I think that is a requirement, and that is lacking in this case. And without those, there's insufficient evidence for the child endangerment conviction as well as the felony. There are no other questions. As I said, we believe that the errors and instructional errors, along with the other issues we've raised, require a new trial in this matter.
Any other questions? Thank you. May proceed, Ms. Lifkin.
Thank you, Your Honor. May it please the court. Again, this is Jody Litfin, representing the state. I can start with the sufficiency of the evidence claim. It's our position that when we look at this in the light most favorable to the state, that we did have enough evidence here to convict of the felony murder based on the aggravated endangering a child statute or underlying inherently dangerous felony there. We would disagree that actual knowledge is required. And I think that the Herndon case does lead, there's some language that can be read, but I think Patillo takes care of that, where this court says, no, you don't have to actually know. So we don't have to prove that the defendant knew that NM here was under 18. But I think there was language that she had a reason to know, or the court just went back to the actual statute, which says, you know, a conscious disregard of the substantial and justifiable risk.
Does that mean the state could prosecute someone if the victim were 20 years old under an argument that they look younger?
I think I don't think it could go that far, Your Honor, because the
Why is
actual.
it that far? I mean, the evidence is going to be whatever the evidence is. And so can you make the argument just based on physical appearance? And so your victim's 20, but their physical appearance makes them look much, below 18. And I'm not sure what that is, but it just does that. Can you prosecute somebody for that?
I don't think it would meet the element of having the victim be less than 18 years old. That's required by the statute. So no, I don't think that works, because it doesn't meet one of the elements of aggravated endangering a child, which is the child has to be less than 18 or, less than 18 years old, under 18 years old. I think it works in this case, though, because she did see the appearance, and the appearance is that 3 out of the 4 of the first group of females were minors. If you look at them in the Axon videos, they look young. I mean,
I've watched all those videos because I'm concerned about this issue, and I'm trying to figure out I looked at those young women and remember, we're just trying to close a 9-month gap, because you've said if the victim's 18 or above, you don't get to prosecute here. So we're trying to close a 9-month gap. I've looked at the photographs of the victim laying there on the slab, clothed, and then I've watched the body cam of the 2 young women as they were taken into the police station, I guess. I mean, we're really just going to throw these videos up there and say, jury, figure out what their age is or what a person would think. And that's a question of fact that only the jury gets to decide without question?
I think so, Your Honor. I mean, I think that's definitely a thing that the jury can determine here and should determine here based on the evidence. They can use, of course, common sense and their life experience to know whether or not these women appeared under 18 or not. And if I can point the court to.
So let me ask the reverse question of Justice Biles' question. As I understood it, he was asking about possibly prosecuting a young, a person who was not a minor who appeared young. So the reverse is a person who is a minor who appears very old, let's just say. And, you know, you can go to any Little League game and see 16-year-old boys that may look 25 potentially. In that situation, what is the threshold of evidence that's required? You know, you have a 16-year-old who looks like a 25-year-old man, let's say. Can you prosecute that even if the evidence all suggests that a reasonable person would not have just sort of assumed that that person was a minor?
I mean, I think we're talking about a lot of things that are very factually.
Well, but that's the point, is this a fact question? And if it is a fact question, what is the precise fact question? Or does the statute effectively make the age of the victim is going to be a fact that probably is not going to be in dispute after everything's said and done. You can pull the birth certificate, right? Is that element effectively strict liability in this statute?
I hadn't thought about that, Your Honor. I don't think so.
Then what is the precise factual question?
Well, and
Because I'm struggling to frame it in my mind. I don't know how to ask the question that the state has to prove. If it's not actual knowledge, I mean, let's say you win on that question. It's not actual knowledge. Could a defendant in a future case argue to the jury, look, it was not reasonable for an objectively reasonable person would not have thought this person was under 18. Is that what the statute requires?
I mean, I think that would be one way to go about arguing.
Well, but what's the right way?
I don't
From your
know.
perspective.
Honestly, Your Honor, I hadn't thought about that, like in a strict liability sense. But when we're looking at the sufficiency, my view of it was when we're looking at the sufficiency of the evidence, if we don't have actual knowledge, which I think is in a lot of cases, right? You see the child, usually actually, I shouldn't say usually, but in cases where we're not dealing with 16, 17-year-olds, you see the child, there is actual knowledge.
Well, right. So the issue doesn't come up, but
Right.
Here the issue has come up. Often, should we be informed at all by the numerous other statutes in which the age of a victim is a relevant fact, which are effectively strict liability? There are numerous statutes that impose either separate crimes or enhanced crimes based on the age of the victim. And it doesn't matter. If you do these acts with the requisite intent, it doesn't matter that you didn't know or even that you were tricked into thinking the victim was older. Is there any relevance?
I guess maybe I would answer that. And is it a reckless crime? Or are we talking about intentional crimes? Maybe that would make a difference. If we look at what we're focused on here, it's the recklessly disregarding the risk that this is a child, right? And shooting into the child. So I don't know if those statutes deal with intentional or knowingly versus recklessly. And I think if you shoot a gun into a group of 4 women that look young, that's disregarding a substantial risk that some of these females are minors.
The jury instruction, though, was specific to this victim, to NM. It didn't just say that somewhere in the group there might have been a minor. It's specific as to NM. That's why I'm kind of laser focused on this. Let me see if you can make me feel better about this exercise. Is there anything else the jury would have had to tag this victim as being under the age of 18 other than physical appearance?
Yes, Your Honor. What I've listed in my brief was, I want to say it's Carmel Brown's interview with law enforcement and then her testimony later. And Carmel Brown and the defendant my understanding of the evidence was they were close friends, like family. So Carmel Brown repeatedly references at least NM as the little girl that was with them, 2 of their little friends. She makes several comments about
But she's never asked whether she spoke with the defendant about that. That's, okay, so, okay.
That's true.
Maybe you've got evidence that that other woman thought these were minors. Still got to, somehow we've got to tag the defendant with this.
Right, and I guess where I go with that is it's the state's position is that's a reasonable inference that if Carmel knew that these two, little girls, or when the little girl fell or the little girl dropped, so did Butler. They've been around each other, and I think there was some evidence of, I think Carmel Brown says they do this all the time. They're constantly fighting with each other. They're beating up their mother, or there's a constant sort of tension between all of these people, between family members. So I don't think this is something that happens. This was the first time this has happened. So I think it's just a reasonable inference to know that if Carmel Brown says that all of this happens all the time, they're all kind of fighting and walking away from each other and then fighting again. I think it's a reasonable inference to know that the defendant also knew that these friends were minors as well.
But did Ms. Butler made some statement, I think, to law enforcement that, can you confirm in the record, did she say something along the lines that I wasn't sure whether that victim was 16, 17, or 18?
My recollection was, I think she asked the detective how old she was. I don't know if she said, I didn't know. I think she said, I didn't know who they were. I didn't know their names.
Okay.
And I don't know if she specifically said, I don't know their age, but I think she said, I didn't know them. I didn't know who they were. And I think she asked how old she was, but I could be mistaken on that.
I guess I'm just trying to figure out how you consciously disregard a substantial risk toward a minor. Maybe I'm asking the same questions the other justices have, is what is the evidentiary threshold for that?
Yeah, I don't know that I have a good answer of like, here's where it is. I'm just throwing all of the facts that we had here to meet our burden that there was sufficient evidence based on those facts and reasonable inferences therefrom. Also, one thing I wanted to mention, I'm not sure if she was there at the time, but I think the first group of females got a ride there. So I think there was even evidence that they either didn't have a car or couldn't drive. So that was something else to throw in as well, where the second group of people did have a car and did show up and were driving. And I think that's everything that I've listed in my brief as far as what we've got to support the sufficiency of the evidence here. I didn't have any other further presentation unless this court wants to direct me to a specific issue.
Any questions, colleagues?
Since there's time left, I'll ask my thought experiment question. There are also statutes that make it a crime to commit violence against certain classes of people. I'm thinking in particular of law enforcement officers, judges, attorneys, community correction officers, etc. And I'm just wondering if does the offender in those statutes have to know? Does the state have to prove that you knew that this was a community corrections officer? As I read the statute, there isn't a requirement. I mean, it's just if you did this and the victim was a community corrections officer, you're guilty.
And Your Honor, I don't have those statutes in front of me, so I don't know. But
Sure, and I know I'm reaching, but like I said, you had a few minutes left.
If it's not like the thing that's coming to my mind is flee and elude, where they have to be in a marked car and they're running, like that sort of thing. But if there's not that there, I guess again, you would just argue reasonable inferences that they did know that this person was a.
So you're conceding that under those statutes, the state has to prove that the defendant knew.
I don't know that there's a requirement for actual knowledge. I don't know that I can.
But the jury
concede that.
instruction told the jury they had to decide that. Because they focused on that victim.
The jury instruction says the defendant recklessly caused NM to be placed in a situation where her life, body, or health was endangered. And I think we've got that. I think shooting someone in the back of the head is endangered. But the risk is not tied to her alone. So I guess we just got the standard definition for a defendant acts recklessly when the defendant consciously disregards a substantial and unjustifiable risk that certain circumstances exist, or a result of the defendant's actions will follow. So I'm not sure if that's what you mean in tying the risk of being a minor to having her actual health, life, and body be endangered.
Well, item number 2 under, and I don't know what jury instruction this was, it was the aggravated endangering a child statute. It said that one of the elements was that the victim, NM, was less than 18 years old.
Yes, that is element number 2.
Anything else, Ms. Lifton? Colleagues, anything else? Thank you. Mr. Meharry, you reserve 3 minutes.
Thank you, Your Honor. May it please the court, just a couple quick things. As far as, I know Justice Wall asked about my client's statements, and on page 10 of my brief, I do list out some of the statements she made during her interview. She stated that she did not know the females at all. She did not even know all their names, and that's volume 19, States Exhibit 1, roughly 1850 to 19-minute mark. And then later in that interrogation, she did ask how old the victim was in this case, and that's about, again, States Exhibit 1, about the 4740 mark. So she did make statements indicating that she didn't know who these people were. She was there with her friends in this fight without a clear understanding of who was on the other side. And I think that shows that there just isn't that evidence for her that she knew had any actual knowledge, and also that there's no reason to think these were minors. And that's certainly the argument we've made in this case. And we do think it is required under the child endangerment statute, whether or not it's actual knowledge or reason to know. The purpose of the statute, I think, is fairly clear. It's to punish people who put minors in danger, whether or not that's a certainty of danger or a possibility of danger. And it's focused on, for that reason, protecting minors.
Could you address some sort of the thrust of my questions, which were looking at other statutes which create classes of victims? And at least it seems to me that we have not previously required either actual knowledge or even a lesser should have known standard. It's just the statute creates these classes of victims, and if your actions, whether intentional or reckless, impact this class of person, you're guilty of this crime.
As far as I know, that is true. That I don't know that there are cases where this issue has been brought up where it's battery of a Leo and the person says, well, I didn't even know he was an officer. He just, for whatever reason, broke into my house. Maybe he was serving a search warrant or something like that, and I defended myself. I don't know if there's a case out there like that or not. But I think the statute here, it does require, as far as aggravated child endangerment, it does require reckless conduct. And that requires a conscious disregard. And I think when you read the statute, that conscious disregard is the consciously disregarding the danger you are putting a minor in. That is, I think, fairly clearly the focus of the statute is protect minors from being even put in the possibility of danger, and to deter those people from doing that. And if they don't know they're minors, you aren't really going to deter them with the statute. So I think there has to be something.
I'm sorry.
Go ahead.
I didn't mean to cut off your argument. But it made me think, if that is the purpose of the statute and there's any ambiguity, wouldn't we want to tie reckless to the conduct and not age?
I think you have to tie it to both. You have to have reckless conduct putting a minor in danger. As I said, I don't think you can separate the danger and the minor, because That's the point of the statute. It's that the minor is in danger here. Not just that random Joe is in danger, but, you know, a 5-year-old is in danger. You know, we see it oftentimes when somebody's charged with DUI and child endangerment because they have a kid in the back seat of the car. Don't put the kid in the back seat of the car. I mean, don't drive drunk either, but don't put the kid in the back seat of the bar. That's the point of the statute.
But if the driver didn't know the child was back there, you're suggesting that would be a defense?
I think I'm not sure how that would work exactly. But I mean, my car tells me when I put a McDonald's bag in the back of my car now. But if the defense is, I didn't even know a kid was there. Maybe the kid's in the trunk. I don't know. But I think you have to have some reason to know, if not actual knowledge, one of those. So if you actually don't know a child's in there and you don't have any reason to know a child is in there, I think that would be a defense, at least to obviously the child endangerment part. DUI, you're on your own. But I think when you look at the statute, that requires either actual knowledge or some reason to know that a child is being put in danger by you. And here we don't think there's that evidence. For those reasons, unless there are questions from the court, we would again ask this court to reverse this for the reasons stated in our brief.
Any other questions, Ken? Thank you, Mr.
Thank you.
Meharry. The next case is State of Kansas versus Verley McCullough. Number 127008. Approach.
May it please the court. James Latta of the Appellate Defender's Office representing Verley McCullough. I'd like to begin with issue 1, whether a reasonable person would feel like they were in custody during the interrogation. And I'm basing most of the facts off of Exhibit D, Defense Exhibit D, which was admitted at the suppression hearing. And between 10 minutes and 30 seconds and 16 minutes, this is what happens. Verley is at the home of his on-again, off-again girlfriend. He's upset. Officers order him in the back of a police car. The door is closed. He is unable to leave because there are no handles in the back and he can't get out. An officer walks around to turn on the air conditioner, and Verley repeatedly asks him to let him out. He says, "Get me the fuck out." Officers do not let him out. Officers instead say they have to go talk to other officers. Officers cover their body cam. They mute it, and we don't know what is said. But we know that they come back, and they do not let him out. Officers then go and talk to then there's more conversation between officers. Verley asks why. He said, "We need to find out what's going on." An officer to Verley, "And we need to talk to you." Verley says, "Why can't we talk outside of the car?" Officers do not let him out. Instead of not letting him out, another officer comes over and confiscates his cell phone. From there, actually 3 or 4 minutes after that, another officer is heard on body camera telling another officer to roll up the window more so Verley cannot get his arm out, presumably so he can't let himself out. Officers then involuntarily drive him to the police station where they interrogate. They drive him in the back gates, down the walkway into the back door of the police station. They escort him to the interrogation room. And from there, that is when the interrogation begins for the next 30 minutes with Detective Sutton.
I watched all of that interaction, and what is the difference between just information gathering and just trying to figure out what happened, get background information, and then begin an actual, as you call it, interrogation? Isn't there a distinction between that?
Well, I didn't see one based on this court's very definition of what a custodial interrogation is. This court specifically defined a custodial interrogation as any questioning from law enforcement when the defendant does not feel when the suspect does not feel they're free to leave or disengage. Any question, and even if that's not the case, certainly the question in this case was to find out what was going on. I mean, to say that, I mean, nobody would throw a witness in the back of a car, a witness who didn't witness anything. They knew he wasn't there. They wouldn't confiscate their cell phone. They also confiscated his wallet on the way up there. So he was in the interrogation room. He'd already asked to be let out. So in that context, who would feel free to say, well, I get to go home now?
Let's say that we agree with you and that it was custodial. How would we then evaluate it under the harmlessness standard beyond a reasonable doubt?
Yes, Your Honor.
Okay, and so is this true that the pre-Miranda statements claiming he was with his girlfriend all night, were those also repeated post-Miranda? So the jury heard it anyway?
Yes, they were.
And then, well, I guess I want to know how it was not harmless beyond a reasonable doubt.
Sure. So first, the statements came in at trial that he was in the hotels. It also had other contradictory. He said he never left the building before and after his Miranda statement.
Right.
So maybe I'm kind of more of a cumulative error view, but we want his whole statement removed because of the custodial interrogation. And then he said he didn't want to talk anymore and they kept talking. So even the post-Miranda statement shouldn't have come in under my issue 2. And the
right, but we're talking about issue 1 right now. So, let's separate it so that it's when we write the opinion, we're going to separate it by issue.
Sure.
So, would you agree then that, well, I guess what you're saying is that maybe it would be harmless beyond a reasonable doubt, but when you combine it with issue 2, then it makes a difference.
Sure. I mean, I guess my first argument would be it's still not harmless given the high burden on the state. And the most important fact of all is that we have a hung jury. We have one juror. So before they played the video and they repeated that he never left, and that came in pre-Miranda. So he did make statements that hurt him pre-Miranda. I want to be clear about that he never left the hotel.
Right, and that didn't come out after Miranda?
That did come out after Miranda,
Right.
but I still think that, I mean, he said something that's harmful to himself and the burden's beyond a reasonable doubt. And one jury already said that wasn't good enough to convict on that, knowing that. One jury said this evidence is so weak, we're not going to convict, knowing that he didn't leave. So if we remove that evidence from a new trial, why wouldn't another jury?
But if he
not
said
convict?
it after Miranda, then it would have come in.
I'm sorry.
When we're looking at harmlessness, we're saying, okay, there was an error,
Right.
okay? Shouldn't have used those pre-Miranda statements. Okay, but there's no issue about the post-Miranda statements. And if what came in pre-Miranda also came in post-Miranda, or I guess what was said pre-Miranda also was said post-Miranda, where's the prejudice?
Well, I mean, even if there's, like, as you said, sure, if there's no prejudice there, then I'll move on to my best
Okay.
argument, which is cumulative error. I don't
Okay.
Waste my time, I see your point.
Okay.
But for cumulative error, we want nothing to come in. And then that goes to the hung jury, where they've already viewed this evidence. So I want to be clear, they viewed this evidence with all these harmful statements, the contradictions, specifically him contradicting himself that he didn't have guns, that he never left the hotel. One jury already said that's not enough to convict. So then if we have a new trial where we remove that evidence that already wasn't enough for one jury to convict, I don't think the state can prove beyond a reasonable doubt that the result would not be different in the next one.
Wait, are you talking about whether he unambiguously and unequivocally asserted his right to remain silent? Is that what issue we're on now?
No, I was still talking about harmless error.
Okay.
I'm sorry.
I'm sorry.
What is the cumulative error that you're relying?
The
And you have
cumulative
to-
error is that combining both the errors.
Right, so you are talking about what Justice Standards is referring to.
Right.
Again, let's assume that we agree that the pre-Miranda statements were error, that introducing them was error.
Right,
And then to get to cumulative, you need to add a second error.
right.
And your second error is he invoked his right to silence.
Yes,
Okay.
So can you talk about the merits of that claim?
sure.
Briefly? Like, in other words, what in the record tells us that he unambiguously and unequivocally asserted his right to
Sure.
silence?
I understand now. Sorry about that, Justice Standards. So for the second error is when the detective was asking him, they had just read him his Miranda rights, and they were talking about whether or not he wanted to keep talking. Do you want to keep on talking about Dion and other stuff? And he said, no, because I don't know where this is going. And that our argument is that a no because statement is an unequivocal invocation of your right to remain silent, that a reasonable police officer should know that they don't want to talk anymore. That the police officer doesn't get to, a person could say no because, and that's unequivocal.
Well,
The reason why,
if the person being interviewed said, no, I don't want to talk to you anymore because I'm cold, and the police say, here's a blanket, they've taken care of the condition, and then the facts are he kept talking, seems to me that that's not the right trigger. To just say no because is good and it is the same as a no.
sure. So I have two responses. My first response is anytime the officers do not get to look at the reason why. We have to scrupulously honor a request to not talk any longer. A no because is I'm done talking, especially under these circumstances where they just read him his Miranda rights, told him he had his right to remain silent.
What case are
But-
you relying on for that?
That's just the general case law that says a reasonable officer would understand
Right,
what,
but I mean, there's also, the case law says that it has to be an unambiguous and unequivocal,
right,
right? And
That's
so
my-
you're saying no comma because,
yes.
and then the question is it equivocal or ambiguous because he says because?
That's my argument, that
And then
anytime,
what case are you relying on for that?
I couldn't find a case where anyone had said no because before.
Okay.
So that's why I'm relying on the general case law. But our argument is anytime there's a no because statement, whatever comes after the because is just the reason why. And that officers, you don't get to look into the reason. Once they say no, it's no for any reason.
So here, as you watch it and listen to it, no, because I don't know where this is going, there's a follow-up that he's actively engaged in regarding, well, let's talk about where this is going. What's your, kind of what's your fear about where this is going? And they have this discussion. Nowhere after that does he invoke or even say, I don't want to talk anymore.
Sure. My response to that would be that the case law has said that you can't, the continued answering of questions can't be used to look backwards to cast doubt on the invocation of the right. So once he said no, because my argument is that's it. But even if this court doesn't like that, in this case, he said no because I don't know where this is going. I mean, he's talking about this case. It's not something completely crazy like I'm cold, I want a blanket. He didn't like where this investigation was going, and he didn't want to talk about it any longer. So at least under these circumstances, that is an unequivocal invocation of his right to remain silent.
Is that question, whether the invocation is ambiguous or unambiguous and unequivocal, is that a fact question?
I think here,
that part
there
of
is
it?
no fact question, so it'd be a question of law, since we know what was said.
Well, what informs us as to whether an invocation is unambiguous or ambiguous?
I mean, I think you look to the whole context, as this court has said.
Right.
So, I mean, to me, it's really one of those questions where we say it's a question of law, but there's really some facts. We really are also kind of looking at the facts.
I guess I'm trying to understand how much deference the district court findings are owed, that this statement or the question which said, do you want to talk more about that, was a reference to the preceding comment about Dion. So under our mixed standard of review,
Right.
what goes into which bucket, which part goes into substantial competent evidence? Probably the totality of the circumstances,
Sure.
right? Okay.
I would say, when they talk about that, the court found that it was referring to the last statement. But the last statement then they also went on and said, and other stuff. And so there was additional stuff that he also said he didn't want to talk about because he didn't know where this investigation was going. And the way I read the district court's ruling is the this and Verlee's statement, no, because I don't know where this is going. He was referring to the investigation. So he was saying, no, I don't want to talk anymore. And that's, after standing up here asking questions, that's probably our best argument, is he said no because he doesn't want to talk anymore about this investigation. When he said this, he meant investigation. And then keeping out all those statements, the pre and post with both issues, then the cumulative error is still beyond a reasonable doubt. And what we're really trying to focus on here is that one jury said this evidence wasn't enough. And so who knows what another jury would do without this additional contradictory statements. And we're really asking this court to just let the jury decide. That's what Verlee wants in another jury trial. And if there's no other questions, I'll say my rebuttal.
Colleagues, any other questions? Thank you, Mr.
Thank you.
Latta. May approach.
Good morning, Your Honors. Assistant District Attorney David Greenwald for the state. May it please the court. I'd like to start with that no because, that second issue, because I think it also addresses the first and the third issue. And what the defendant is asking is for this court to create some sort of overbroad rule that if you say the word because, then it doesn't matter what the equivocation is afterwards. And so as the example was brought up, I don't want to speak anymore because I'm cold. If you then remedy the I'm cold factor to it, the defense is asking for it to just be over, period, because he said that triggering word because. And it's our contention that's far too overbroad. And there is instructive case law from this court on when somebody makes what appears to be an invocation of their rights, but then makes an equivocation where they say, no, I don't want to talk anymore because it hurts too much. And then this court said it was not in violation of that suspect's rights to then continue questioning because it hurts too much was an equivocation. So here, when Mr. McCullough says, no, because I don't know where this is going, the defense is arguing he doesn't know where the investigation is going. I don't know that it matters whether it's where the investigation is going or whether it's, I don't know where that questioning is going, because as soon as Detective Sutton clarifies what that questioning is, where this is going, they then continue on. He's now handled that equivocation. And I think what's really important here is that Mr. McCullough in his statement says, after that, I know my rights. So he is indicating to Detective Sutton that he knows that he can invoke. He knows he has a right to counsel there. He says, I don't want to talk because I don't know where this is going. And after he's told where it's going, he says, I know my rights, and then continues on with the line of questioning. And he's actively engaged in that questioning. He's asking questions of Detective Sutton, trying to gain more information. And so because there was this equivocation, it's not an unequivocal invocation of his right to remain silent, there is no error. And that goes to the harmless error aspect of it. And it goes to issue one, as Justice Standridge brought up, which is that even if they were questioning him without Miranda inappropriately for that first 30 minutes, those statements all come in post Miranda, and that would have cured the error there as well. But going to issue number one, it's our contention that there was no error in not Mirandizing him for those first 30 minutes. So obviously you have to be in custody and you have to be interrogated. And he certainly was asked questions. The question is, was he in custody? And there's the 8 non-exclusive factors, and none of them weigh more than any of the others, right? So it's not that if I win 5 and they win 3, I win the whole thing. But the count is 6-2 in favor of this not being in custody.
Just set the factors aside for a minute.
Yes, sir.
How in the world could this defendant have thought he was free to leave? I mean, he couldn't. Even if he did think he was free to leave, he couldn't.
Absolutely.
I'm struggling with that part of your argument.
Yes, sir. So there are absolutely times when somebody is not free to leave, but they're not in custody. For instance, a car stop. And we don't require officers to Mirandize somebody while they're getting a speeding ticket, right? So there are times in which somebody can be detained and not be free to leave. And I think the important clarifying part here is the circumstances in which Mr. McCullough came into contact with the police, right? So he calls 911. They come and meet him at the crime scene. And as the district court noted, you almost never see the defendant staying at the scene of the crime and being the one to call the police to say, you know, I did this thing, right? And so the circumstances when she initially is coming into contact with the police is he's a witness to a crime. He called 911 and reported that this crime had happened. And what the testimony from both the detective and the officer who responded on scene and transported him was that he was extremely distraught and emotional, was trying to get back into the crime scene. So they initially put him in that car to just cool him down and to not allow him to tamper with that crime scene. And then on scene, before they transport him back to the police station, they tell him, we want to talk to you because you're a witness. You called the police. And so absolutely, he's in the back of a car. He can't, open the door and get out. And he certainly he's emotional and distraught. But I don't know that that rises to the level of custody when you're being told repeatedly that you are just a witness to this. He wasn't handcuffed. He didn't have any of the trappings of restraint that you see when somebody is
Well, he
usually
was
put in the back of a
forcibly
car.
detained and taken to the police station and not permitted to leave.
He didn't ask to leave once he was at the police station, right? So he's in the car and he says, I want to get out. And they say, we want to talk to you. You're an important witness to this crime. They drive him to the police station, but at no point while he's in that room does he say, I want to be done. Can I leave? Any of those things. Now, would he have been free to leave if he had asked? We don't know because the record's not developed enough in that. He's in the room. There was an officer outside to help tend to any needs he might have had. So if he needed to go to the bathroom, he could have told the officer and they would have escorted him to the bathroom because the police department doesn't allow people just unfettered access to the bureau.
It's
But-
correct that his phone and keys and wallet were all taken from him, right?
Yes. But his phone being taken from him was of his own doing. Now, the wallet and the keys, absolutely. And I think the case law kind of suggests that equals custody. The phone was taken from him because he says the Ring doorbell is missing, but I have the app on my phone. And again, as a key witness in this, the officers are going to want to look at the phone. In fact, a substantial portion of this questioning revolves around asking him about being able to get the video doorbell evidence because it's such important evidence in an investigation, let alone a homicide. And so the taking of the phone is, again, Mr. McCullough himself is saying, I've got this key evidence, and they're trying to preserve it like they were trying to preserve the crime scene.
Wasn't that done prior to when they discovered the Ring information and he gave them the email and all of that? His phone was taken prior to that time, wasn't it? He didn't hand it over as a result of, I didn't see that happen.
No. So I think he told them at the scene that he had the app,
I'm curious, at the scene, Mr. Lattis suggested that there was body cam and other typical investigatory tools that were deleted or not or turned off. Is that right?
So officers can mute body cameras. You see this often in investigations when they want to have a conversation with a superior officer on the scene, or they want to talk about something that maybe they don't, about what is our internal department policy on something, or not in the context of this, but you see a lot when an officer might get a call from their child. I've actually seen that in one of my cases before where an officer mutes his body cam so he can take a phone call from his daughter and then hangs up.
Is that what happened here?
It's not what happens here. I can't speak to why those officers muted their body cams. My best guess, based on my experience, is that
it was more than one officer that did that. Is that true also?
Yes, John. But I can't speak to why they would have done it other than based on my kind of experience in dealing with these investigations, is that usually it's to go speak to each other about what's our strategy moving forward here? How are we going to cordon off the scene? Who's going to take him to the scene?
And why is that so vital to not have anybody know that later?
I couldn't begin to tell you. I can't say that it's my preference that they do that. I can just tell you I've seen it happen regularly. And so because our contention is he's not in custody for those 30 minutes based on kind of looking at those 8 non-exclusive factors, that's also not fair. That the officers, if you look at all of these different factors, certainly he was transported to the scene, but he was allowed to leave. They only interviewed him for about 30 minutes prior to reading him Miranda. It was only Detective Sutton doing that interview. And then at some point later, post Miranda, Detective Bundy comes in, but they were friendly with him. They got him water. They said, if you need anything, just knock on this door. There was no handcuffs. There's no real physical restraint, but Detective Sutton repeatedly told him that he was just a witness. And it was only after the they gained more information from the scene, and Mr. McCullough's statements stopped making sense on that they started to develop him as a suspect, as somebody who we think maybe this is problematic. And so then they Mirandize him. But that first 30 minutes, he wasn't in custody. I mean, he certainly was transported somewhere, but if he had asked to leave, he may have been allowed to leave. He never tested that theory. But all of those other factors point to it being non-custodial. Then they read him Miranda. He makes that equivocal statement. They clarify where they're going. And that then cures kind of any sort of errors because he functionally waives his right to remain silent. He engages in that conversation with them. So then there is no harmlessness, or there's no error. And so there's nothing to factor in for issue number 3. But if we think that there is some sort of error as it pertains to issue 3, the fact that a case mistried, I don't think is instructive of whether or not it points to one thing or another. Without talking to the jury and having it on some sort of record, nobody knows why the first case mistried and the second case didn't. There's any number of reasons why that could happen, going simply as far as somebody might have picked a bad jury, for the state at least. But if you look at all of the different evidence that the state had, that they presented to the jury, certainly Mr. McCullough's statement is part of it, but they have, whenever you're looking at who a suspect is and trying to prove a case, you look at motive, means, and opportunity. There was evidence, irrespective of his statement, that Mr. McCullough and the victim had gotten into a big argument the night before, which points to the motive. The means and the opportunity, there was testimony, completely irrespective of his statement, that he had a key, he had access to the house, and the victim's son who lived there said that he had locked the door that night. The police said that there was no forced entry, which strongly indicated that the person who did this had to be able to access the house without some sort of forced entry, which again creates the opportunity to do this and the means of entering the home without some sort of kicked in door or anything. Then you've got the volume of video surveillance evidence that they were able to find. And so whenever the police are looking into an investigation, certainly they're going to start looking around the scene of the crime for traffic cameras, Ring doorbell cameras, all of those things. They identify what they think is a significant vehicle, which is Dion Rucker's vehicle. And they're able to trace that and track that back to where it went. And then they're able to develop their investigation from there. So they know that whoever did this, or they at least suspect whoever did this, was using Dion Rucker's vehicle. So who has access to that? Well, Dion Rucker functionally had an alibi because of the testimony of the people from the motel and who was with her that night, and it was the defendant. And so all of this paints a picture of what is the state's evidence, looking at the entire record going into argument. And if you were to excise the defendant's statement, it certainly weakens the state's case, but I don't know that it changes anything because you've got all of this video evidence. You've got testimony from these witnesses at the scene of the motel that all kind of, again, point the finger directly at the defendant. So I don't have anything else for my presentation. If your honors have any additional questions, I'm happy to answer them.
Colleagues, any further questions? Thank you, Mr. Greenwald.
Thank you.
You reserve 3 minutes, Mr. Latta.
May it please the court. The only thing I'll add is if your honors, when you're talking about harmless error, whether by itself or cumulative, please remember that one jury, all this evidence the state talks about, one jury viewed it. We presume they follow the instructions. They said it wasn't good enough for premeditated murder. They said it wasn't good enough for second-degree murder. They basically said it wasn't good enough to convict that he killed the victim. And unless there's any other questions, we'll stand on our briefs.
Colleagues, any other questions? Thank you, Mr. Latta.
Thank you, your honors.
And thank you for your arguments during the 9 o'clock docket. Court will be in recess until 10:30. Thank you.